Welcome to part 6 of my free YouTube course about franchise law in Ontario. As we continue learning about Ontario's Arthur Wishart Act, otherwise known as the Franchise Disclosure Act, in this chapter, you'll learn about a concept known as rescission, which concerns certain situations where a franchisee can void a franchise agreement and walk away even after signing. This concept is found at Section 6 of the AWA, and this section of the legislation is divided into 6 subsections. As you can imagine, a lot of lawsuits are filed in Ontario, which engage Section 6 of the AWA because of the number of situations where an agreement might need to be rescinded. You can see subsection 1 of Section 6 on the screen now. You can pause the video here if you want to read it. I'm going to provide a plain language explanation of each subsection instead of just reading the law to you. This particular subsection gives a franchisee powerful legal protection if the franchisor messes up the disclosure process in any serious way. Under this subsection, if the franchisor didn't give you the disclosure document on time, or gave it late, or failed to include something they were legally required to include, like a proper financial statement or material change update, then you have the legal right to walk away from the deal. You can rescind or cancel the franchise agreement without penalty or obligation, meaning you don't owe anything further under the agreement, but you must act within 60 days of receiving the disclosure document. In simple terms, if the franchisor didn't follow the disclosure rules properly, you get a 60-day window to back out cleanly, even if you already signed the agreement. This rule exists to give you a fair chance to make an informed decision, and to hold franchisors accountable when they cut corners or try to pressure you without proper disclosure. Once that 60-day time frame passes, it would seem that this specific rescission right is gone, but keep listening and you'll see that the story doesn't quite end there. Let's take a look at subsection 2 of Section 6 of Ontario's Arthur Wishart Act. This subsection allows a franchisee to rescind a franchise agreement within 2 years of signing it with no penalty if the franchisor never provided a disclosure document. However, if you've made it this far in the course, you probably already know that in order to fully understand that law, you can't just read the legislation by itself. You have to look at how courts have interpreted the law, meaning you have to actually read the relevant case law. This subsection is a perfect example of how the case law is just as important, if not more important, than the wording of this legislation. The courts have said that if a franchisor gives a disclosure document that is so incomplete or defective that it effectively amounts to giving no disclosure at all, then a franchisee may still be able to cancel the deal under the 2-year time frame instead of being stuck with just the 60-day timeline. Let's break that down by looking at 2 real court cases in very simple terms. In the case of 2611707 Ontario Inc. versus Freshly Squeezed, a man named Bernard Yeboah bought a Freshly Squeezed juice franchise after seeing an ad for a location in a hospital food court. He met with the franchisor and was given a franchise disclosure document just before signing the agreement in December 2017. After a few months of trying to operate the business, he decided to walk away and served a formal notice to rescind the agreement. He claimed that the disclosure he received was so bad that it was essentially the same as receiving nothing at all. As you can imagine, Bernard was in a tough situation because he was already outside of the 60-day deadline described in subsection 1 of Section 6, but he was still well within the 2-year time frame in subsection 2 of Section 6. The court agreed with Bernard. The court said that there were 3 serious problems with the disclosure. First, the financial statements were incomplete because they didn't include any notes explaining the numbers. Without those notes, it was impossible to understand what the financial data meant. Second, the franchisor didn't tell Yeboah that they hadn't yet signed a lease for the location. This meant the franchisee had no way of knowing what the rent terms would be or whether he'd even be guaranteed a location at all. Worse, the franchise agreement didn't give him any way to back out if those future lease terms turned out to be unreasonable. And third, the franchisor failed to mention that this particular location was the first Freshly Squeezed store ever opened outside of a shopping mall. That was a big deal because it meant there was no track record to rely on. This was a test case, and the franchisee didn't even know it. Because of these major gaps, the judge said the disclosure was so flawed that it didn't really count as disclosure at all. The franchisee wasn't given the information he needed to make a smart investment decision, and that's the whole point of the Arthur Wishart Act. When the case was appealed up to the Court of Appeal, which is Ontario's highest court, that court also agreed with Bernard. They emphasized that the law is meant to protect franchisees by requiring franchisors to be fully transparent, and that the test is objective, meaning it doesn't matter if the particular franchisee was extra savvy or did extra research. What matters is whether the disclosure was good enough that any reasonable person could have made an informed decision. In this case, the disclosure was insufficient, so the court said the franchisee had the right to cancel under subsection subsection 2 of section 6, even though the wording of that part of the law literally only referred to situations where no disclosure was given at all. Like I mentioned before, this is a great example of how the case law might come to a slightly different conclusion compared to just reading the legislation by itself and interpreting it literally. Moving on to subsection 3 of section 6 of the AWA, this part explains how a franchisee must go about giving notice if they want to cancel a franchise agreement. It's not enough to simply say you're backing out, you have to do it properly and in writing. Specifically, the law says that the notice of rescission must be in written form. That means you can't just make a phone call or casually mention it in an email thread. You need a clear, formal message that says you are rescinding or canceling the franchise agreement. It doesn't need to be complicated, but it does need to be unmistakably written down. The law also sets out how that written notice has to be delivered. You can give it to the franchisor in person, you can send it by registered mail, you can fax it, or you can use any other delivery method that's legally allowed. Registered mail is often used because it provides proof that the notice was sent and received. Finally, the notice must be sent to the franchisor's official address for service, which is usually listed in the franchise agreement. If the agreement says someone else, like a lawyer or agent, is designated to receive legal notices, then you can send it to that person instead. In short, if you're a franchisee and you want to rescind your agreement, make sure you do it in writing, deliver it the right way, and send it to the correct address. If you don't follow these steps, the franchisor could argue that your cancellation wasn't valid. Moving on to subsection 4 of section 6 of the AWA, this part deals with the effective date of a rescission notice. In other words, it explains exactly when your cancellation of the franchise agreement becomes official, depending on how you sent the notice. If you deliver the notice in person, then the rescission takes effect on the same day. That one is straightforward, hand it over, and it's official immediately. If you send it by registered mail, then the law assumes it becomes effective on the 5th day after it was mailed. This gives time for the mail to arrive and avoids arguments about when it was received. If you choose to send the notice by fax, the timing depends on what time of day you send it. If the fax goes through before 5 p.m., then the notice is effective that same day. But if you send it at or after 5 p.m., it doesn't count until the next day. Finally, if you use another method that's allowed by regulation, then the effective date is whatever the regulations say it is. This gives the law some flexibility to adapt to new technologies or delivery methods. So overall, subsection 4 of section 6 is about pinning down the exact date your cancellation takes effect, which can be very important for legal deadlines. It depends entirely on the method and timing of your delivery. Moving on to subsection 5 of section 6 of the AWA, this part adds an important clarification to the rules about when a notice of rescission becomes effective. It says that if the effective date, based on the delivery method you used, falls on a holiday, then the notice doesn't officially take effect until the next day that is not a holiday. This rule applies specifically to the situations in clauses B, C, and D from the previous subsection, which cover registered mail and fax deliveries. For example, if you mailed the notice and the 5th day after mailing lands on a statutory holiday, then the law treats the next regular business day as the effective date. The same goes for faxes if you send one before 5 p.m., but that day turns out to be a holiday, it won't be counted as effective until the following non-holiday. This provision helps ensure that a franchisor isn't caught off guard or held to a deadline on a day when their office is legally closed. It also gives the franchisee certainty that their notice won't be considered late just because it coincided with a holiday. In short, the law pauses the clock for holidays to make things fair and predictable for both sides. Moving on to subsection 6 of section 6 of the AWA, this part explains what a franchisor must do once a franchisee has properly rescinded the franchise agreement. It lays out clear financial obligations that the franchisor or their associate must fulfill within 60 days of the effective date of rescission. First, under Clause A, the franchisor has to refund all money the franchisee paid, except for money that was specifically used to buy inventory, supplies, or equipment. So if a franchisee paid an initial franchise fee or development fee, that has to be paid back, but the cost of physical items like cups, machines, or ingredients is handled separately. Next, under Clause B, the franchisor must buy back any inventory, meaning things like food or merchandise, that the franchisee purchased under the franchise agreement and still has on hand when the rescission takes effect. The franchisor must pay the same amount the franchisee originally paid for it. Similarly, under Clause C, the franchisor must also buy back any supplies or equipment, again at the full original purchase price the franchisee paid. So if the franchisee bought a yogurt machine or branded uniforms through the franchisor, those must be repurchased at full value. Finally, under Clause D, the franchisor must compensate the franchisee for any other financial losses the franchisee suffered while acquiring, setting up, or running the franchise. This includes costs like rent, renovations, or local advertising. However, the franchisor gets credit for the amounts already paid under Clauses A, B, and C, so those aren't double counted. In short, this subsection ensures that if a franchise agreement is canceled properly, the franchisee isn't left holding the bag. The law puts the financial burden on the franchisor to make the franchisee whole, as if the deal had never happened, within a clear 60-day window. Congratulations! You've completed Part 6 of this course about franchise law in Ontario. In the next video, we'll talk about Section 7 of the Arthur Wishart Act, which deals with the franchisee's right to sue the franchisor for damages for misrepresentations or a failure to disclose information. Don't forget to subscribe. I'm Ryan Keeney, and thanks for watching. I'll see you in the next video.